Thanks, Jen. And I want to build on what you just talked about. I mean, I think one of the things that's very clear about your leadership at FinCEN is the expansion to these non-traditional financial institutions that you just mentioned. Talk a little bit, if you can, if you will, about the different kind of levels they're in. And I'll start it this way. We have put together a gaming committee of AML professionals who are, both hungry to work together and share information, and they obviously recognize that things need to be done. There was the American Gaming Association report about where they fit. Talk a bit about that industry. Obviously, there have been some fines and penalties, but I get the sense that, in general, they're all working together to improve both the knowledge base and their expertise. What do you sense there? What do you see there?
I think that's generally right. It's not that the expectations or the rules have changed in any way since I've had the privilege of being at FinCEN. I think what we've tried to do, as I said just a moment ago, is level the playing field. Our depository institutions and our institutions that have federal functional regulators like broker-dealers and in the futures industry are asked to do a lot, do a lot. We've talked a lot about the culture of compliance in that industry, but as the director of FinCEN, looking across all of the financial institutions, I think it's important that we pay attention to all of them, the risks in all of them, and so we've made a concerted effort to try to do that. I think we're making progress. On the evolution scale, so to speak, I would put depository institutions at the most evolved in terms of the sophistication of your programs and the understanding across institutions of the need for AML and how to do it. And some of the others are behind. I just mentioned the real estate industry. It was just only maybe 2 years ago that I made a trip out to Las Vegas and had a serious chat with our casino industry folks about maybe taking this a little more seriously. We've had chats with the armored car industry about thinking about their business and the risks there. So it's a process we're continuing and very committed to. We want all of our financial industry members to feel like all of your partners across the different segments of the industry are taking it seriously, are playing their part in the same way that you are, quite frankly.
And I think the traditional financial sector does get that, and I think that's part of it. It's not so much misery loves company, but if there's a financial aspect to anything that you do, there should be some obligations. And I know we talked about that when the Patriot Act was being formed. We said everybody should be covered. Everybody has a role to play, and obviously you folks have put that into practice. Yesterday we had a regulatory panel. Andrea Sharon from your group was on the panel. Dan Stepano from the OCC talked about technology from this standpoint. The OCC just issued a paper on innovation that I'm sure you're aware of under Thomas Curry's byline, and it was about we don't want to stifle innovation, we want to understand it, but we have to make sure that it's properly, not even regulated, but it's properly part of the infrastructure. So even though you're an enforcement agency, you obviously do a lot of outreach. If you can, talk a little bit about the outreach to the financial technologies, because we again, just kind of pointing to ourselves again, we've created a financial tech group, and it's got Google and PayPal, all those folks involved, and even Ripple Labs. And what Ripple Labs said, what I thought was particularly important, is they've learned from their mistakes. They've issued white papers that better explain both how they've improved, but how the infrastructure is. Talk a bit about both technology and how FinCEN does outreach and works with those entities. Sure.
So we've spent quite a bit of time with first the nascent virtual currency industry, so the Bitcoin, Ripple, et cetera. And I think our initial message was welcome to regulated industry. Right. We had some guidance out that made it clear that some of the businesses there are covered by the AML rules, by the Bank Secrecy Act, which was kind of news to the crowd. And then they weren't sure what that meant, and there was a little bit of a discussion, wait a minute, we're disruptors, so we don't have to do this regulatory stuff. And we walked through that, how that probably wasn't right. then you would probably get a kick out of this. They said, hey, this stuff's pretty hard, and it costs a lot of money. I said, let me introduce you to some folks. And so we brought one of them onto the Bank Secrecy Act Advisory Group, where we have trade association and financial institution members, over 50 of them, all from all across industry, and said, let me introduce you to some other people that have kind of gone through this before you, and they might be able to give you some ideas. So we saw a transition from the initial shell shock stage to kind of, I don't know if it was the 7 stages of grief, kind of anger, acceptance, and we kind of got there. But they're a new industry. We're still working with them. We worked with the IRS, who does the examinations for money services businesses, to come up with an examination plan and training on how to examine the virtual currency industry. We did the first round of exams. Gosh, I think it was last fall, and we had folks from FinCEN out on those as well. I think the thing that I've tried to challenge the industry, and I still see the opportunity, whether it's the industry as disruptors or the industry in partnerships with traditional financial institutions, there's some opportunity there around also using technology, not only to create business efficiencies and cut costs or increase revenue, but also to use that same technology to do AML better, and likely cheaper. And so I think one of the challenges is trying to have these great innovators, these great minds teamed up with people who understand AML to try to apply that in that area as well. So there's some opportunities there.
We mentioned that yesterday as well. The data that's now available that wasn't available before is pretty phenomenal. When you hear these folks from the groups that we just mentioned talk about the information, and we all know, in terms of linked analysis and all of that's here now. That's there. So to your point, if you can use that for proactive AML intelligence gathering, that's pretty powerful.
And one of the things we have already learned quite quickly is they file some good SARs.
Right.
Our analysts love their SARs. They're data people, right? They love this IT stuff. So the information they put in SARs is incredibly helpful, certainly in a cyber investigation, but also in terrorism investigations, things related to ISIL. I think we've learned from working with them to give out broader guidance to industry about how helpful it is to get IP addresses together with the timestamp, together with any type of legal entity identifier, but to really kind of put all of the IT data in the SARs as well is incredibly valuable.
Since we're talking about financial technology, I'd be remiss if I didn't ask you this. Ray Kelly sat where you were yesterday, and I asked him his view on the Apple FBI issue. And I'm curious, with your background as a prosecutor, being in the Justice Department, obviously there's some push and pull there. What's your thoughts in general about that?
Well, I think the whole issue has great parallels to the work that we all do every day. It's about getting the balance between providing security and having privacy right. So when you start talking about terrorism threats, national security threats, criminal threats, there is a need at times to give up some level of privacy to enable government to do its job to go after those threats. So the idea that you go to a judge and get a search warrant to go into someone's house, one of your most private places, to be able to look at that. We have agreed as a country that that's appropriate under certain circumstances. Now, as we watch technology develop and the world and communication change and understand that the most important information may not be in a house, it may be in a phone, it may be in financial records, it's continuing that discussion both in the United States and globally about what's the right balance. And that balance changes over time in reaction to world events. And it's a little bit of a pendulum that you can watch swing back and forth.
The other thing that's been in the news, and you've obviously opined on it as well, is the leak of the Panama Papers. Obviously, offshore banking, good and bad, there's nothing new there. We've all seen it. There's always been those issues. Obviously, there's been a renewed focus by the general media now because of the way this come out. We're covering, in some of our sessions, we'll talk a bit about that. And obviously, the part of your bio I didn't read is obviously your extensive work on the misuse of shell companies. So talk a bit to the audience about what you've said about this recently, but also somebody here that I talked to saw one of your quotes and said, well, I want to see what she thinks about LLCs in the States and corporate formation here, which you have opined on. So give us your broad sense of what do you take from the papers, but also offshore versus onshore. And I know we have a pending rule, but give us a sense of where we are.
Sure. So as I alluded to in the remarks, as it involves real estate, but certainly much more broadly, the use of shell companies to make transactions opaque has been a favored tool of criminals for decades. And for at least a decade, probably longer, it's been an issue with which I've been seized. I think I've testified before Congress 3 different times about the issue, both at Justice and at FinCEN, written about it, talked about it extensively, and my view is we need more transparency, not just abroad in a company set up in an offshore jurisdiction, but here in the United States. And so we have kind of our approach domestically to this, which is a broader Treasury approach of which FinCEN's a part. We have the rule that FinCEN's pushing, the CDD rule, which would require financial institutions to know the natural person behind accounts set up in the name of a U.S. legal entity or any legal entity. We have been consistent out of Treasury and at Justice back in the day as well of asking and working with Congress on a legislative solution that would require here in the United States, when someone sets up a company, an LLC or a company, to identify the beneficial owner behind that company, both at formation and at the transfer of that company to another, the sale of it to another individual. So we continue to support the idea that legislation in that area would be helpful. And then we've pushed on the international standards front. It's not U.S. We certainly have a problem with our shell companies, but we don't want to just fix the U.S. and then have a loophole where there's a number of other countries that have the same issues.
Let me talk about the states again. I just don't get it. Is it as simple as they'll lose business if Delaware has to tighten things or Nevada? Is it that simple, or is it a little more complicated? Because I've seen testimony from whoever the state regulator is in Delaware, and they just simply say it shouldn't be our responsibility, it should be the financial sector, that sort of thing. But what is the logic behind them not doing more? I know you're supporting that they should do more, and many are, but I just can't wrap my arms around it. Is it just simply a revenue play?
I think that's a question for them.
Yeah.
So I'll let them sit on the hot seat and answer that one. There are several states that have played a positive role in trying to deal with this issue. The problem is we need a 50-state solution. Right. You can't have 40 states who are on board and 10 that aren't, sure. And then those are exactly where the criminals are going to go. So getting consensus across 50 states has been a challenge.
Okay. You mentioned GTOs, and we've done a session on geographic targeting orders. Obviously, an old authority that you revised, and I actually think, from doing this for so many years, that was actually a very excellent tool created a bit ago. And like I said, you rediscovered it and used it. Now you've usually explained a couple of places where you're doing it. To the extent that you can, is there intent to use it? Again, expand it, do it in other places? I assume it depends on what's going on, but just talk a little bit about that, because you mentioned it in your remarks, but I think GTOs is a really proper use of the authority that you folks have.
Yeah, so I think one of the great things about coming to FinCEN was the discovery of all these unique authorities and tools that FinCEN has at its disposal. Some that have been used, some that have been used but not that often. And I think the GTO is a really useful tool. It's not just, it kind of provides law enforcement with those, Colonel Mustard with a rope in the library moments where they solve their case through the clues that they get from the GTO. But the GTOs also play an important role in helping us at FinCEN to collect information on the broader trends and then use that to think about regulation. So whether it's guidance, whether it's rulemaking. So in the real estate area, we can not only help law enforcement by giving them clues that come out of the GTO, but we can look at that data and understand the illicit finance risks for a fairly low investment. All right, they're 120 days long. They're limited to a geographic area. We can go in, get some information, and kind of have our hypotheses about what a rule might look like or what we need to think about, but it's a chance to test it without having yet imposed any real burdens that are long-lasting on industry, and see where our understanding is right and where it's wrong. So I'm a fan of the tool. We've used it for trade-based money laundering in Miami and the LA Fashion District. We used it for armored cars across the southwest border. We learned a lot about CMIR reporting, it led to some great discussions with our Mexican colleagues and their version of CMIRs and how they match or don't match and what that means, and has made both of us think about rulemaking and activity along the border to focus on cash. So it's a good tool.
The culture of compliance that you also referenced, I think was an excellent advisory that resonates obviously far beyond AML, and obviously it's also something that FATF has talked about. We talk about it in this world. How do you think it's going since you've released it? Because clearly it's all about the compliance people in this room. They get it, right? It's all about people in senior management. Above them are boards of directors, and we did at our Vegas conference, I think we did a quick poll and just said, basically what percentage of folks thought that their boards of directors were actively engaged in AML oversight, and it was only 50-50. And this is coming from an AML group. I think that's pretty low, and that was last, September, October. How do you think it's going? Just, what's your perception? Obviously, there's no metrics on this, but what do you think?
So before I answer that question directly, just a quick backstory on that advisory. So a lot of the material in there was generated from the cases that we had done at the asset forfeiture and money laundering section against financial institutions over the years, and just trying myself to go through them and see what higher level themes were in there. And so I had started working with a colleague to turn that into a law review article, because when you're at the Department of Justice and you're an attorney, that's your kind of only outlet for writing. Right. So we were starting to do that when I took the job at FinCEN. So I brought it over and said, what do we do with this? And now we have an advisory. In terms of where is the culture, what's my perception of where we are culturally? I think we're making strides, and there's a ways to go. I think one good question is, and the one you asked is, are the boards engaged? Because you do need that buy-in from the top. But also when you have the buy-in from the top, particularly when you think about some of the really large organizations out there, how is that trickling all the way down to the line and across business and across several different countries or wherever they're operating? I think there's challenges around that as well. So it's a theme that we need to continue to hit. It's one of those that I think we're tired probably of hearing and talking about. Beat me over the head one more time with culture of compliance. But it's not, I don't think that message is so much for us in this room. Right. That message is really about taking it more broadly across our institutions. So I had heard a very good ambassador at one time say, it's not until you're sick to death of your talking points that you're delivering to a foreign government and you don't think you could possibly say them again. That's the first time they're actually hearing them. Right. And you have to say them several more times before they then go to understanding them. So I think we're partway through this journey.
Another thing people are sick of hearing is de-risking. So Rick Small sat up here yesterday and said absolutely hates the term. Others have said the same thing, although I noted that in Canada they actually use demarketing in advisories. And I actually talked to Nick Burbridge there and I said, you're actually encouraging this by using that term because you're using a term. And he said, you know what, you might be right. So they may actually change that. But so de-risking is a broad-based area. Financial inclusion, loss of data, if people go underground, that sort of thing. I won't ask you about the Trump proposal, but as we know, the Trump proposal,
because I won't answer.
Yes, yeah, exactly, would be a clear form of de-risking if that were to go into play. But I just want to get your thoughts. You've opined on this, and I'll lay it out this way. I think to some degree folks are talking past one another because it's not simply a question, in my humble opinion, of just the banks that are exiting accounts. I think it's a combination of real or perceived reg concerns. It's also risk reports that come out that banks have to react to, right? So then it's also risk reward. It's a business decision to some degree, but it's also, can I mitigate the risk? Will the regulators accept that? We're not going to solve it in the next few minutes here, but what's your take in general on it? Because I think it has to be a combination of all of those groups to get together if we're going to really solve this.
Yeah, I think it's the drivers are incredibly complex issue. And it's something that at the Treasury Department we spent a lot of time thinking about and looking at, researching, engaging in dialogue with counterparts domestically and across the world, quite frankly. We are concerned about financial inclusion. We do want financial transparency, though, at the same time. And we understand that both of those bring benefits for economic development and stability. On the flip side, we do take seriously the prospect that there could be wholesale de-risking of certain jurisdictions, products, et cetera. The kind of short-term good news is we have been working with the World Bank and other partners to look at the issue specifically of cross-border financial transactions and whether there's been any systemic breakdown in that. And thus far, the data suggests that no, there is not that. So when we think of larger systemic risks, we're not yet seeing them. We're continuing to watch, continuing to engage, taking all kind of concerns very seriously on that front. But as we think through, and then it's, even if it does happen, is it because of AML enforcement and that's the only thing? Is it supervisors that are being tough on the ground even though Washington's saying the right thing? Is it something totally different? Is it just business decisions, et cetera, the costs, et cetera? And I don't know that there's any one right answer. I think it may depend on the institution, the situation, et cetera. I think what we've tried to do, and we've done this through BSAG again, is bring different constituencies together to talk to one another. So, and I think that's been helpful. We've also done that bilaterally. And that's been helpful to bring together the public and private sector and different bilateral discussions. And Sarah Runge has really led a lot of those to great effect. But we find the more that we can get people in the room talking about the particular issues they have and the drivers, that there are solutions to them. But it's painstaking work. There's not one decree of just do this and the issue will go away, a simple one-sentence black and white rule. That doesn't exist. It is about getting people in a room to say, how do we trust one another? How can we rely on the information you're giving us to apply it to our own risk standards? And that's painstaking work.
To your point, we're actually going to be doing something with the World Bank this summer, invitation only, sort of closed door, everybody from the different categories that you mentioned, because I think unless you talk, and I totally agree with you, it's not just one angle, it's a whole series of things. So I think early on it was people just throwing stones back and forth, and I think now there's a recognition that if we really want to solve this, it's the whole risk infrastructure, it's the business infrastructure, it's international chaos that's going on, frankly, that leads to a lot of this. It's great to say we need to send remittances to Somalia, but that's one of the most unstable governments in the world. And so if you're a financial institution, what do you do? Because all the reports coming out of other places in the government talk about piracy and everything else. Are you supposed to say, you feel sorry for folks here that want to send money to their families, but you got to be careful. You obviously don't want to allow or enable funds to go in the wrong hands. So I really think that's where you have to get, as you're talking about, get everybody together who has a stake in this.
Yeah, these are difficult issues, and there's difficult issues for industry to grapple with, difficult issues that governments are going to have to grapple with here in the U.S. and abroad, and I think there's also a role for organizations like the World Bank.
I also asked Ray Kelly yesterday about the horrific attacks in Brussels and Paris and San Bernardino. From a financial aspect, from a financial intelligence aspect, not what's your take on those acts, but what more can be done with the financial sector? Obviously, The financial sector quickly reacts to requests for information. They do all of that. But there's obviously a financial component. Seems relatively small, for at least from what you read. It doesn't take that much money to cause these things. But just give us your sense of all that's going on.
I'm so glad you asked that, because I think this is an important message to get out. The reporting that you all are doing on terror finance is incredibly important and being used. So at FinCEN, we get about 55,000 filings daily of all the different reports we get. We run business rules over them, much like a large financial institution, or not even a large financial institution these days, so that we can sift through and figure out what we should be looking at. So we have rules related to ISIL and foreign terrorist fighters. I think we have about 20 or so rules related to that now. They kick out about 1,000 equivalent of alerts a month that we then have our analysts combing through. About 10% of those make it into an analytical report that we write up and distribute to law enforcement, the intelligence community, folks involved in anti-terrorism in the intelligence community, foreign partners, et cetera. And we send those out. We have done a couple things based on that information. First of all, it's been used extensively to keep people out of the U.S. that we think are a threat. So working with Homeland Security on that. FBI has worked with it extensively to focus on individuals of concern in the U.S. Our foreign partners in Belgium, in France, all across the world are looking and using these reports to great effect to help their efforts. One of the key things that we learned is the information is particularly helpful in identifying foreign terrorist fighters and their facilitators. And that's important because these are folks you want to know who they are and where they are. They're the ones who are traveling perhaps into the conflict zone, back out, and then they're the ones that you see ended up doing attacks. So everyone has an interest in understanding who they are. So your information has been used greatly. In fact, just in 2015, so the reports we sent out that are ISIL related, I was shocked, quite frankly, to see 61% of them came from depository institutions. I thought it's 37% is MSBs and like 2% securities. I actually thought MSBs was going to far outstrip what we saw out of depository institutions, but that wasn't the case. And it was certainly a lot from our largest financial institutions, but not exclusively. We've had some great reporting from community banks, from credit unions. So it's fabulous reporting. It, in turn, has led us to look through all of it, come up with red flag indicators, send that out as an advisory back out to industry. Now, here's what you should be looking for. We did our first advisory last year, and initially in the first week, it had something like 34,000 hits of people reading it. Just by way of context, a normal advisory gets about 3,000 hits a month. It immediately showed up then in our reporting as we started getting reports from institutions who had clearly read the advisory, were referencing it, were calling our terrorism hotline with tips, all of which we were using and getting out to law enforcement right away. We ended up doing another advisory. That one got 55,000 hits right out of the box. And that one also we used with the rest of the world. So we have 150 FIUs, financial intelligence units, that are part of the Egmont group where we share information. We shared that advisory across all of the FIUs and encouraged all of them to get it out to their financial institutions. So now it's out globally. But that's the power of the information that you provide to us. When we use it well, we can flip that right back and help educate you on what additional information is helpful.
That's great. We just have a couple of minutes left. I do want to ask you kind of a final thought here, and that is your time at FinCEN. A two-part question. What are you proudest of, and what do you hope to still do in the role? What else for you remains to be done? But first, what are you proudest of either working on or doing or completing?
The proudest stuff is usually not the interesting, how do you make a difference in the world stuff. I think I'm proudest when I think of the people at FinCEN. And really watching the growth there of the different individuals, the excitement and the curiosity around how can we take, we're a small agency, we never have enough people, we never have enough of anything, but how can we use that to greatest effect? I think we've really evolved into a place where there's a lot of creative thinking and a lot of energy, and we've evolved from maybe being a little bit behind where we should have been to now, I think as you mentioned, really being at the forefront of FIUs globally, and not just saying that because we're the United States and we tend to say that, but it actually being true. And so that's been an exciting evolution to watch, that type of growth. In terms of what we still have to do, I think we're still thinking about leveling that playing field. And boy, I'd like to see this transparency and shell company issue get over the finish line on all the fronts that I mentioned.
Well, Jennifer, thanks so much. I think everybody in the audience is well aware of FinCEN's website and the information that they push out. And just another plug for that. I've always thought from the SAR activity review to all the other data that you push out, it's both a training tool and maybe could help with that culture of compliance when you pass that information up to the top and you explain how it relates to your own individual institution. So I want to thank you for both coming today, but also all the work that you and your staff do with the industry, and the leveling the playing field, I think, is something that a lot of folks here that are here because they want to know what they need to do next. So really appreciate you coming today. Thanks so much.
Great.
Let's thank Jennifer.
Thank you.